Hey, good afternoon, and welcome to the Pelicast. I'm Sarah Harbison. I'm General Counsel at the Pelican Institute for Public Policy. Today is Tuesday, February 9th, and in normal times, we would be getting ready for the first of our 6-night parade marathon here in New Orleans for Mardi Gras. But we are about a year past 2 weeks to follow the curve, to flatten the curve, excuse me, and no Mardi Gras parades this year. So we thought instead we might be able to make it up to you by having a discussion about government overreach. I know that doesn't really make it any better, but we do what we can, right? You may have heard that the Pelican Institute recently joined with our friends at Pacific Legal Foundation to bring a lawsuit against the Louisiana Department of Health on behalf of a woman named Ursula Newell-Davis. Miss Ursula is a social worker. She's an experienced social worker with many years of working with disabled children and providing mental health services, who saw a need in her community and thought that she had the skills to fill that need. And when she applied for a business license with the Louisiana Department of Health, the state had other ideas. They said not so fast. So joining us today is an attorney from Pacific Legal Foundation, Molly Riddle. And Molly is going to talk with us about Ursula's story and some of the claims that we've brought against the Louisiana Department of Health. Welcome, Molly. Thanks for joining us.
Thanks so much, Sarah. Great to be here.
Glad you're here. So Miss Ursula, she is a social worker. She has about 2 decades of experience providing mental health services. She is a mental health consultant. Why can't she open her business?
Yeah, great question. She has everything you would expect her to have to be qualified and able to start up. Unfortunately, in Louisiana, the licensing process is a 2-step process. And the first one is related, nothing with health and safety. That's the second step that gets into that. The first one is you simply have to prove whether or not your business is needed. And so that probably sounds unusual because it is. It's a pretty outrageous law. And Ursula went to do that. And the government said that she wasn't needed. They decided that her experience and her 20 plus years in the field was irrelevant and that they knew better. And so they denied her.
So I can't imagine the government saying, oh, we don't need another mattress store. I mean, does this happen in any other field or any other type of business?
It does. We see it a lot in the medical field. These laws historically came on the books and they applied to things like hospital beds and facilities and things like that. Unfortunately, as we so often see, regulations end up growing and they capture more under their umbrella. And so services like what Ursula wants to provide have been added to Louisiana. Actually, only in 2012 was it that her services were subject to this need requirement. And then we see similar laws. They're called certificate of need laws in other states. Over 35 states have those. So unfortunately, we see it a lot.
So it's called the facility need review. And you also mentioned a certificate of need. Why do these laws exist?
Yeah, so like I mentioned, we saw them more as they apply to actual facilities and to medical equipment. And the thought was, it was back even before the 1970s, 1960s, about whenever we saw them cropping up in states. And it was based on the reimbursement system in which states received reimbursements for their medical expenses. And based on that, there was an incentive there to open more facilities, to add more hospital beds. And that would mean you would get more money from the federal government. Recognizing this, the federal government instituted these laws to take that incentive away. However, since then, the reimbursement system does not function that way anymore. It is simply based on if you're actually, performing the procedure or performing the scan or whatever it is, or using the facility, that's in which you're going to be reimbursed. And so the original justifications are no longer there. However, as we so often see, once laws are on the books, it's very, very difficult to get them off, especially whenever they're protecting the financial interests of existing providers.
And you mentioned that a facility need review requirement came into play in 2012. So that's even after the reimbursement model changed, and after we knew that these laws don't have anything to do with the health, safety, or welfare of the people who Ursula wants to help and who are the most vulnerable in our society and who are indeed in need of protection. So why in 2012 did this requirement suddenly come onto the books?
I don't know the legislative history behind it of exactly what led to it, but we see oftentimes regulations that will expand despite them not having any relation to the health and public safety of society or in regard to people. And even there have been decades of studies done now that have shown how harmful these laws are. Because as you can imagine, if you're imposing a need requirement and you're not letting new businesses enter the market, you're going to have a short supply. And that short supply leads to higher prices. This is, basic economics. And so recognizing that, the federal government actually has called on states to repeal these laws and to get rid of them. They're like, hey, this is, first of all, the original justifications for having them no longer exist. And second, they're demonstratively harmful. They're driving prices up, they're driving supply down, and they actually lower quality as well because there's not that pressure for the existing businesses to innovate and to maintain good, high quality things. So it's from every angle you go at it. There's no justification for them staying on the books or adding them, except for the fact that special interests who have, perhaps the legislature's ear, they want them on the books because it protects their pocketbook.
Now, when Ursula first applied for a license, did she get any guidance from the Department of Health or anything to help her demonstrate to the decision makers that there was a need? Or was she aware of how many other providers there were or who they might be or what types of services, how they might compare and how her business is different than the others that are already operating?
Sure. Yeah. No, what initially inspired her idea to open this business and start it was based on her experience. It was seeing, hey, there are a lot of families that need my services for her to go in and provide those social services to them. And so she decided to, apply, pay the fee, make that personal investment of time into it. She did contact the Department of Health. She requested to meet with them face to face so she could discuss and articulate in her own words why she thinks she's especially qualified for this. And the Department of Health denied. They told her no, and they also provided no guidance. They just said, the burden is on you for you to demonstrate why you're needed. And it's a very abstract thing to think about. Typically you don't like whenever you're thinking about opening as it's a risky thing to do. Right. If it worked out, the success is great, but no one knows for certain. And so she did her best. Her inspiration for wanting to start her business was to counsel kids and have early intervention for the children of New Orleans as she sees the crime rate growing. She's the mother of 2 sons, and she knows that when kids are left without the proper support that they need, they can fall into the wrong crowd and lead to crime. So she cited in her application actually the growing juvenile crime rate in New Orleans and hoped that would convince the department, but it didn't.
And something in particular that is, I think, unique to the services that she provides are that she is interested in working with children who are disabled. Maybe you're left alone because their parents work odd hours or they work at night. They're left alone. And best case scenario, maybe their homework doesn't get done. Even worse, their personal hygiene falls by the wayside, either because of their disability or the lack of supervision or an adult teaching them. And even worse, as you mentioned, these kids can turn to crime. And this wasn't convincing, I guess, to the Louisiana Department of Health that these are really great reasons. This is a wonderful service that she could provide.
Yeah, they weren't, unfortunately. And the denial that she received was actually verbatim identical to all of the other applicants who were denied, which nearly 75% in recent years have been denied from starting up and opening a business like Ursula's. And so this suggests that the Department of Health isn't taking a very close look at whether or not the business is really needed. It kind of seems just like a rubber stamp of denial. And so, you would think, given how Ursula's story is really moving and is very powerful and like what she wants to do and the kind of change she wants to bring to her community, you would think that would convince anybody. But unfortunately, that hasn't been the case.
And I want to move on to talk about the legal arguments that we're making in this case. But I do want to mention that it is incredibly brave for somebody like Ursula to step up and challenge the government. She's a social worker. You have to have a license to be a social worker because, and that is something that the government does have a valid interest in protecting is people who would provide mental health and social services to the vulnerable members of our community. And the Louisiana Department of Health regulates those licenses, or there's a department within the Department of Health that regulates those licenses. So she's really an incredibly brave woman for taking on the system like this and the status quo. So bravo, Ursula. Really great job.
Yeah, absolutely. Retaliation is always a concern that our clients have, and they've got to, make the decision if they're willing to go. It's very much the David and Goliath dynamic of they're David and the government is Goliath, because this seems like, can they ever win? But for Ursula, she's an entrepreneur as well, and she has a existing consulting business that she works with those social services agencies. And for her, she's like, I'm doing this not only for me, but I'm doing this for the future entrepreneurs who come after me that want to open up. Like this can't persist.
Absolutely. So let's talk about the legal claims that we are making in this case. Why is it that considering whether or not there are enough, this weird definition of enough, whatever it is, enough providers in the area, why is that unconstitutional?
Yeah, so it implicates the right to earn a living, which is it's a constitutional right. It's one that so easily is forgotten. But I think that this past year, with the pandemic and all of the shutdowns, we as a country have had a wake-up call of just how fundamental our right to go to work every day and right to make money and right to provide for our families is to us. And so here, we brought claims under the 14th Amendment to the U.S. Constitution, so the federal Constitution, as well as the Equal Protection and Due Process Clause of the Louisiana Constitution. And we're arguing that under both of those, the facility need review is violating her right to earn a living.
So the equal protection argument is that she is being treated differently than others. Is that right?
Yes, correct. It's the equal protection argument can go, it's a pretty nuanced one, and it kind of depends on how the case evolves. But one perspective on it is that, yes, that licensed facility need review holders now are receiving favorable treatment under the law that she is being denied. And you can treat people differently. We discriminate, the government discriminates every day of how are you, but you must have a good reason for why they have such discrimination. And here we contend that there's no legitimate reason.
And there is a good reason to make sure that somebody like Ursula is qualified to provide those services, as we've discussed up and down. But it's really up to the community and parents who have disabled children or children with particular challenges to evaluate the services that are available and say, well, I already have a relationship with Ursula and I would prefer to work with her. And there is this other provider who is in the area, and there may be something that's great about them, but they just don't provide specifically the service that Ursula can provide. And Ursula is being treated differently than that existing provider for no reason other than they are an existing provider.
Right. And even whenever you think about, a babysitter could come in and provide the same services that Ursula is providing without needing a license. But because Ursula is the professional doing it, she's subject to, which, intuitively it makes, okay, if you're going to advertise yourself and all these things, which we are not challenging any of the licensing related to that a social worker must have to exist, but a babysitter would be able to come in and operate. But then Ursula coming in, who's arguably more qualified, especially because, as we said, Ursula will be working with special needs communities. So these kids need somebody that has experience doing that. But the babysitter would be subject to a less stringent regulation than Ursula would.
Mm-hmm. And we of course are not taking any issue with the fact that Ursula or any of these other providers are not qualified to provide the services that they require. We believe in Pacific Legal Foundation, I'm sure believes that it should be up to the parents and the people. They should have some choice in the marketplace for these types of services.
Yeah, absolutely. I mean, choice that's what makes America great, is capitalism and being able to have people compete against each other. And that's going to make everyone better. It's a win-win-win. Under the facility need review and the reality that the government has created, it's a lose-lose, both for the public, for consumers, as well as for the entrepreneurs who want to come in and make things better. It's a win for the special interests who are lobbying to keep these laws on the books, but it should be that choice. And as I mentioned before, the licensing process in Louisiana is 2 steps. So first, you must prove you're needed. And then second, you have to show that you're qualified and all of that. This lawsuit doesn't touch on that second step. And so there's no argument to be made. I believe that the market, without even that second step, could decide who's qualified or not. But even for the people who are skeptical, that would remain in place.
Absolutely. And something else that is raised in the lawsuit is the privileges or immunities clause. Can you talk about that a little bit?
Yeah, absolutely. So as I mentioned, we are challenging Louisiana's facility need review under the 14th Amendment. And so there are 3 clauses of that amendment, and we are challenging the law under all 3. And so there's privileges or immunities, due process, and equal protection. And so the privileges or immunities, unfortunately, this clause was in large part gutted by the Supreme Court many, many years ago in a Supreme Court decision that just had a very narrow interpretation of the law. And so since then, it has not been interpreted to strike down laws like Ursula's. However, there is building momentum among some of the justices and some other federal court judges throughout the country that believe a fresh interpretation of that clause should be had, and we should see it, but the law moves very slowly. And so we continue to preserve that issue. It would likely be something that the United States Supreme Court would have to reach, as the lower courts are bound by that Supreme Court precedent.
Sure. And are there any other arguments in the lawsuit?
I think we pretty much covered them. As I said, we're bringing on the Louisiana Constitution as well. We oftentimes see with state law that they have similar counterparts to the federal provisions. And so here, the idea in economic regulations under the federal Constitution have received great deference for almost 100 years now, since the New Deal back in the 1930s. And so sometimes state constitutions can offer more protection to people's right to earn a living. The courts will be more engaged under the state constitutions to potentially strike down a law or recognize that right to earn a living. And so that's our hope. Kind of gives us 2 bites at the apple. That's the strategy.
Sure. And I forgot to mention at the top of the Pelicast that if you have any questions, you can go ahead and drop them in the Facebook comments section. And if we have a chance, we'll make sure that we get to those. Molly, can you tell us a little bit about Pacific Legal Foundation?
Yeah, absolutely. So Pacific Legal Foundation is a public interest law firm, and we litigate in a variety of areas. Those include property rights, equal protection under the law, economic liberty, which is my group, and separation of powers. And so we bring lawsuits that are designed to vindicate not only our clients' rights, so in this case, it would be Ursula's, but to protect the rights of all Americans' constitutional rights. And to do so, we hoped that that case that we design, it can set a precedent that can later be interpreted to laws down the road, to put limits on what the government can do with our constitutional rights in mind, and to respect those when drafting laws.
And Pacific Legal Foundation, it's a really wonderful group. I've been with Pelican Institute for a little over a year now, and we all work on the same team. We have the same goals at Pelican Institute: economic liberties. We're interested in people's right to earn a living in the legal, lawful profession that they choose. And a lot of times our interests align. So we do work together a lot with Pacific Legal Foundation. It's a really fantastic group, and I've been really fortunate to learn a lot. I'm brand new to the public interest litigation world, so there are a lot of really fantastic mentors in the organization.
Yeah, thanks so much. Well, it's been great to connect with Pelican Institute as well. I think having boots on the ground in a state is so helpful in us kind of knowing the lay of the land and how to best live.
For the cases, what's going to happen next?
Yeah, so we filed the complaint a couple of weeks ago, and next we are expecting a response from the government later this month. I believe it's February 23rd. So once we get that response, that'll determine how we proceed. So oftentimes we get motions to dismiss from the government. So we would respond to that if that is the case, or we'll get an answer. And then from there, we'll potentially move into discovery and see the lawsuit through. So we're hoping for a speedy result, but the wheels of justice turn slowly sometimes. So we'll be staying tuned.
The wheels of justice are, I don't know, they're different in COVID times.
They are. Everything's different in COVID times.
Everything's different. I know. Pantsless oral arguments on Zoom. I mean, I haven't done them, but I've heard all about them.
Yeah.
Well, Molly, I like to in the Pelicast with a fun question. Is there anything on Netflix, HBO, any streaming service, any podcast, anything great that you can recommend to kill some time?
I started a new show last night on Netflix. It's called Call My Agent. It's actually a French TV series, and it's all in French. So I tend to not pay attention when I'm watching shows, and I can be on my phone or doing other things. But when it's in French and you have to read the subtitles, you can't take your eyes off of it. So I started that last night. It's quite good. I think everyone can't travel right now, so we're just resorting to watching, shows about traveling or shows taking in place in different locations. So that would be my recommendation.
I started streaming, speaking of foreign language programs and having to pay attention to them, I started streaming something called Borgen on Netflix. It is a Danish political drama about, it's fictional, but about a woman who becomes Denmark's first female prime minister. And it's interesting how their government works, the coalition style government. It's obviously very different from our own. And from there, I went down another Danish rabbit hole. There's a series on HBO Go called The Investigation. And it's about the journalist who went on to the guy's homemade submarine in Sweden, and she didn't come back alive. That's another program in Danish that you have to pay attention to while you're watching. And if you like a good docuseries, we started The Lady in the Dale on HBO, and it's about this car from the 70s called the Dale. And it was supposed to be the response, like it was created, I guess, in response to the gas shortage. And it was supposed to be a 3-wheel car that gets excellent gas mileage. And there's some plot twists in there. It's everything is not quite as they seem. So that one's worth checking out too.
Interesting. Okay. Well, I studied abroad in Denmark, so I'm always anything Danish I'm interested in.
I love it.
Yes.
Anything else?
I guess if anybody wants to follow along in Ursula's case, you can visit pacificlegal.org. There we have a case page, and we'll have all the case updates. I'm sure Pelican will be posting about it as well on their website. So I encourage everyone watching to follow along.
We've got we'll post updates at pelicaninstitute.org. Hopefully we can have Ms. Ursula on for a Pelicast in the next month or so. And we'll be sure to keep you updated on any new developments in the case.
Awesome. Thanks so much, Sarah.
Thank you, Molly. Thanks for joining us. Everybody have a great Mardi Gras. Bye.